I'm going to be talking about the use of AI in the legal academy. And that's something that a lot of people are very, very uncomfortable with. And I have to tell you, if it's done poorly, I'm uncomfortable with it as well. But what I've tried to do is see what will work and what will not work. And what I have done is tried to focus on the instructor side as opposed to the student side, to use it in a way that maybe some of us haven't thought about, okay? So that's what we're going to be going through. But as you can see there, I sort of used, and with IRB approval, I sort of used the class I had last semester in Torts 2 as a proving ground to see what we might do together as to what would work and not work in using AI in the classroom, but primarily, again, using it on the instructor side. So we have some challenges facing us today in the legal academy. And we don't want to give away doctrinal teaching. We need to teach lawyers how to think like lawyers, how to do case analysis, and all the things that we as lawyers were brought up on. But things are changing. And I compare what's happening right now to what lawyers dealt with in the Industrial Revolution, the computer age, and the internet era. And that's generative AI. And I think it's a fair comparison. Frankly, I think generative AI is going to ultimately have more of an effect on the practice of law and the teaching of law than all of the other three eras, formational eras that we talk about. So it's not, as I said there, whether we should be using generative AI, but how we go about using it to reinforce the competencies that we want our young people, our young lawyers, and our older lawyers to have when they graduate. So the stakes are really real. A lot of law schools are still restricting the use of AI heavily, and I understand that. I don't know that there's really much place for artificial intelligence in the first year. Definitely not in legal writing. I know that some will disagree with me. I haven't been convinced yet, and I've seen a lot who have argued otherwise. So when you graduate from this restricted academic setting, you're going to be going into a law office or a government office or something else where they're just going to assume, because you just graduated and you're smart and capable, that you're going to know how to use these tools. And we already see that happening. We see young associates who are getting called on the called on the carpet in court for hallucinated cases. Don't look for a partner to have your back if you're improperly using AI in the law office, and yet you have these terrible deadlines that you have to meet. They're expecting the world out of you. You're trying to give it to them, and you don't really know how to handle the tools. And that's very, very scary, because just one hallucination that's published with a large ticket sanction could ruin your career. It's that serious. And so that's one of the reasons I believe that we need to be talking about it. That's a great quote there from Boyd and Fry. If lawyers do not know how to use AI tools well, they're bound to use AI tools poorly, because there is little question that lawyers will be using them. What I want everyone to see is that we need to be using it as an opportunity, okay, as opposed to a risk. We need to use it correctly, or let me tell you, and you already know it, the risks are absolutely profound and out there. So modern professional competence is going to expect that our students know how to use these tools, and we have to equip them, I believe at least, to recognize, manage, and respond to those requests and what everyone is seeking out of these new lawyers. So in Torts 2, we did a number of exercises using generative AI. We didn't throw the doctrinal away. Okay, I teach for 3 hours. I have that luxury. The first part of the course was traditional doctrine, okay? Lecture, question and answer, discussion. But the second part of the course then would dive into these unique generative AI problems, and then also sometimes the students were using generative AI as well. But what we were trying to do is help them with skills training, okay? That's what we were using it for. sort of as a lattice or structure upon which they could start building a skill set, especially those students who aren't fortunate enough to be in a clinic environment. Because even with the bar exam, as we know, the next gen bar exam is going to be focused, or at least partially focused, on skills training. So this is what Gen AI made possible for me. Now, I spend about 2 to 3 hours a day keeping up on developments. I get up about 4 or 5 in the morning. I don't want you to think I'm taking a lot of the workday. I routinely have, Google Gemini, ChatGPT, Claude open on my desk space. I'm not using it to do legal research or to write opinions or anything of that sort. But when I have a question, a lot of times it's a lot quicker to go out there and check multiple models to see what they're thinking. And then, of course, I check everything. You can't trust a prediction machine to give you right answers, but it can at least give you a start, and it might just give you the right answer that you can quickly confirm and be certain of. But as you see up there, it helped me quite a bit. I drive from Charleston every week to teach, and that takes a lot of time. And I'd like to spend more time on coursework and practical exercises, but it's very difficult. Gen AI helped me in a tremendous way to do that. But it was also a benefit to the students. I mean, scenario realism, we'll be there shortly, was just really incredible, I think. So, not only, though, did we use Gen AI, rely on Gen AI to produce exercises, but the students were able to see the benefits and limitations of Gen AI in a very safe space before they get out into the practice of law. So these were some intersecting learning objectives that I felt were achieved by way of the class. And you can see up there competence, judgment, and AI literacy. And all of these were under constraint. I mean, there were very difficult time requirements on the students that I often extended, but they had to think quickly and they had to think on the fly. And as you'll see, some of them were interactive with a very smart computer talking back in the vernacular. So this is how the class was formatted: 36 students in 12 groups of 3. I told you how we split up the class. When we did have to be in an adversarial posture, 6 of the 3-person groups were plaintiff and the others were defendants. And these were the type of things that we went into in graduated fashion over the course of the semester. We're getting all of this substance and doctrine in the first part of the course, and then we're immediately applying that doctrine and substance using Gen AI models. And there was more than just that, okay? But we didn't have enough space on the slide. So let's take a look at the exercises now that I've bored you to death. First of all, how many people in here are using a chat bot, whether it be Gemini or ChatGPT or others, for either their schoolwork or in their law practice? Just raise your hand. Liars. I know it's twice that many, but anyway. Don't be ashamed that you're using it. Just don't use it wrong or use it, heaven forbid, in violation of the college's expectations. So this was the Blue Ridge Energy nuisance situation. We went over nuisance law and some other things from a doctrinal standpoint, and then we pivoted to something that was a little bit more challenging and skills-based. So you're going to see here in a moment some witness statements, conflicting witness statements on elements of nuisance law that were in contest. And my thought was that all of it, from the witness statements to the documents that generative AI generated for the sequences and experiments, were very, very realistic. But I'll let you make that judgment. These were some of the characters. There were others. I'll let you read those real quick. And I'm going to work from here to play a video so you can get a sense. I don't have time to play the entire video of these characters, but I'll tell you this. I created these characters, 6 of them, created the scripts for them, and wove them together in less than an hour, okay? I didn't write the scripts myself. I explained to a chatbot, hey, I'd like you to create a factual scenario, and I'd like you to have 6 witnesses. and I'd like this many witnesses to be in this character and this many in this character. You know, some of my prompts will run 250 words, but the more you give the chatbot sometimes, the better, although the research is still out on that. So I'll let you take a look. I'm going to skip through them, but I'll give you a taste of each individual.
Collins, and I've served as the operations manager at Blue Ridge Energy for 12 years. Our facility operates under all required permits issued by the West Virginia Department of Environmental Protection. We follow noise monitoring standards, and our readings consistently fall within legal limits.
So it's so funny. You may see those people walking behind there. He's telling everyone how they keep this dangerous area locked down and nobody's allowed in. So I thought the students would find that humorous.
The Dawson family has complained repeatedly.
Can you all
but
hear?
To our knowledge, these complaints don't align with the actual data we collect. Last spring, 2 members of the Dawson family were caught on...
80 Local Martinez, Director of Community Relations at Blue Ridge Energy. We employ over 80 local residents, many of whom live within 5 miles of our site. We've sponsored scholarships, athletic teams, and infrastructure improvements in... Entering on company property undermines trust. It also exposes the entire community to risk if equipment...
Should have told you a little bit about the factual scenario. It was a gas compressor station that had just huge noise levels. The company said they were in compliance. The family that lived next door said they were totally out of compliance. And to prove it, 2 family members went on company property and took some readings and recordings. So the family is seeking to allege a nuisance claim against the company. The company then was put in the position of a counterclaim for trespass.
Is tampered with. While we recognize no industrial operation is perfect, we believe Blue Ridge has acted responsibly. Care?
My name is John Dawson. My wife and I have lived on our farm for 27 years. Since Blue Ridge expanded their facility 3 years ago, our lives have changed. At night, the compressors roar like jet engines. Our windows rattle. My wife wakes up with headaches from the vibrations. Home no longer feels like home.
I'm Emily Dawson. I grew up here. I'm now in college, but live at home when classes aren't in session. My high school years were miserable after the expansion. I couldn't concentrate on homework because the low hum and rattling never stopped. Big company.
My name is Tom Watkins. I live less than a mile from the Blue Ridge facility. To me, the noise is no worse than trucks on the highway. You get used to it. I've never smelled anything that bad through proper channels.
I'm Sarah Green. I live about a half mile from the Dawsons. I can confirm the noise is real. On humid nights, the odor from the facility drifts straight across the valley. My kids have asthma, and it gets worse when the smell is strong. I respect the company provides jobs, but that doesn't erase the...
By the way, ignore those YouTube ads on the side. You never know what they're going to put out there. And I didn't even want to look because I was terrified. So you get a sense of what you can do. Now that video lasts about 3 minutes. So that's what the students had. 6 witness statements over 3 minutes that address trespass and nuisance claims. But it wasn't just that. We had other exhibits. We had a document package as well. The documents were even created by generative AI. And let me show you, well, the technology has advanced even in 5 months. I'm going to show you one of the documents that I'm going to use in the fall. They weren't this sophisticated, but it will now turn out documents for exercises like this. That looks like it came from a hospital to me. And it will come in an 8.5 by 11 sheet on PDF, in a PDF file, and the students have to go through these. Now, it's not a long document package, about, 15 pages, but it'll have medical notes, it'll have notices from the Department of Environmental Protection that say that they're within noise limits, a whole lot of conflicting, friction there for students to try to work through, figure out, and come up with a response to the exercise that was required. So go ahead and read just for a moment about what the exercise was. I hate the word weaponize. I've just been around lawyers too long. Everybody done? Okay, so what was the learning value of this exercise? I felt like there were three things. It gave them familiarity with the Gen AI platforms. I didn't just dump these witness statements on them. I told them where they could find this particular app. It's by HeyGen, by the way. And, you know, I think of a written fact pattern that I used to give the students for group problems. This was so much richer, so much more engaging. It wasn't the flat, you know, type of fact pattern that students are used to when it comes to law school. And I still use some of those, but not in the exercises. But the big one was evidence sorting under pressure. I was positively amazed at how well the students did when they were pressed, when they had, you know, this time constraint on them and they knew they had to move very, very quickly. They did a magnificent job. Some of them are in here and I can see them shaking their heads, yes. The next one was the Hammersmith crisis simulation. So basically you've got a partner at a law firm who files a complaint and then disappears. And so the students had to fix things. We'll talk about that in a moment. But I'm going to play part of the senior partner's address to all of the students. They weren't broken down between plaintiff and defendant groups in this one. They were both working in a crisis situation in a law firm and a plaintiff's law firm.
Good morning and welcome to Hammersmith, Anvil & Saw LLP. You've just joined as brand new associates, and I wish I could say you had time for orientation, maybe a welcome lunch. But no, you're walking straight into a crisis. Our managing partner, Magnolia Livingood, has, let's say, departed abruptly. Rumors range from Tahiti to witness protection, but wherever she is, she's not here. And she left behind a case that is, frankly, a mess. Here's the situation. Our client, Mountain Vista Timber, a small West Virginia company, signed a 3-year supply contract with Allegheny Construction Supply. Relying on that deal and on repeated assurances from David Clark, ACS's CFO, Mountain Vista spent over $1 million on new equipment and expanded operations. Clark acted like an advisor. Memorandum on my desk laying out how we respond. Cover every option. Argue why negligence survives under the special relationship exception in Aikens vs. DeBow. Defend the fiduciary duty count. Are there other approaches or options we should consider? If so, lay them out and discuss them. You wanted real work? Here it is. Forget easing in. We have a nervous client, a motion on the table, and the next move is ours. Now get to it, and remember, I want that memo on my desk in an hour. Tick-tock.
So how did I create that? 20 minutes. I didn't even have to do the script. I explained the problem and the vision that I had for the problem. It created the script for me. It even gave me his name. I pasted that into the program that I use, and it took care of the lip syncing on its own. Did a magnificent job. You can pick the character. You can pick anybody you want, or you can pick the stock characters that they have, but it's an instant witness evaluation if you're using it for that, or in this situation, a character that is a partner in a law firm. So go ahead and take a look at that. It just further describes what I did, and this wasn't an unusual amount of prompting. It wasn't anything that was crazy or over the top. It was actually pretty straightforward. How much time do I have? That's not going to be enough. I hope you all don't have anything to do. But anyway, I promise it'll be worth it. Okay, so these are the types of things we were covering in the doctrinal section that we then took account of on the practical or the drafting side, the skills side. And what happened is Ms. Livengood filed a complaint that was just a disaster, okay? And the students, there's a motion to dismiss that's pending now on Twombly and other grounds, and the students have to figure out how to fix it. So not only do they have to think about how do we respond to the motion to dismiss, but how do we do the drafting of an amended complaint? Now, I didn't make them do both of those documents. It was just too early for that, and the time pressure was too tough. But I had them write a memorandum to me about what the flaws in the complaint were and how we procedurally go about fixing things. So these are just some of the things that I wanted to accomplish, and I felt like we did. You can see them up there. But one of the big things was the reality of law practice, just to get them to have that sense before they go out. It's very uncomfortable to be under a time pressure. I still don't like it after 32 years, but they need to know what's coming. But just to apply Rule 12b-6, to see a motion to dismiss and then you have to respond to it or map a strategy for responding to it, all those things are extremely helpful, I think. Okay, next we did a demand letter. I don't know how many instructors require students to do that, but they're at least going to assist on that pretty quickly when they start at a plaintiff's law firm. So they did interviews with an interactive chatbot. What I did is gave them a prompt to read in to a Microsoft chatbot. Now, it didn't look real. It looked more like a little blue blob, okay? You don't usually have a client who walks into your office who is a blue blob, but maybe some of you do, I don't know. So that wasn't realistic, but just in 6 months, wait till you see how that's changed. So these were the scenarios. I asked the chatbot, I can't remember which one it was, to come up with a variety of scenarios, 12 in number, that had different misrepresentation, factual patterns, and also it gave me a script for each one for the particular student group out of the 12 to read their scenario in to the chatbot and then to have this discussion with the chatbot. And if you have questions, technical questions along the way, please stop me. I'm happy to fill it in. Sometimes I assume things and I shouldn't. So these are some of the things that I think they got out of it. They really had to listen carefully to the responses from the chatbot and then do follow-up questions, which I think was critical, and do it under, again, a time constraint. I think we had a 10-minute limitation on the free platform that we were using with Microsoft. So this is not the chatbot that I used in the fall, but this is the one that I'm going to use coming up next fall. And see what you think. You'll see how things have changed. So you can see when you select this item, you can set up an entirely new knowledge base for it by uploading documents, prompts, for instance, for a complex course exercise, or you can rely on the embedded chatbot to do that work for you. What I often use is the difficult conversation role play. So we've got that on, and we're dealing with Brian as a professional. You can, if you don't like Brian's voices, use a different voice if you want. But let's go ahead and get started and demonstrate.
There, what challenging conversation would you like to practice today, and how can I help you role play it effectively?
So Brian, what I want you to role play as, it's an individual who signed up with a health club for a 1-year membership, and they engaged in some fraud that you're going to create and make up. And I'm going to ask you questions. I'm going to role play as a lawyer in an initial consultation. You've come to me to help me get you out of this 1-year contract, although I can't imagine why you'd spend that much money on me to do that. But basically want to do that scenario. And you just are going to have to make things up as you go as I ask you questions.
So I'll be Brian, who signed a 1-year health club membership but has a tricky situation. Let's start the role play whenever you're ready. Just ask your first question.
So Brian, what brings you into the office today?
Thanks for seeing me. I signed up for a year at the health club, but I found out they were charging me for services I never received, and I feel trapped in this contract.
So what was your discussion with them like? Can you give me some more detail?
Sure. When I signed up, they promised personal training sessions and access to special classes, but I've only been able to use the gym. I feel like they misled me to get my money.
Well, that's very unfortunate. I'm glad you came to see me. Do you know the names of the individuals you dealt with and what roles they held at the club?
Yes, I spoke mostly with a sales rep named Lisa, who assured me about all the perks. There was also a manager, Tom, who I talked to when I raised my concerns, but he didn't help much.
So, was Tom rude at all, or do you feel like he may have tried to hide the ball on you at all, or anything like that?
Tom wasn't outright rude, but he definitely brushed off my concerns and seemed more focused on keeping me as a member than addressing my issues. It felt like he was avoiding the real problems.
What do you want out of this case if we do decide to pursue it?
Ideally, I want to get out of the contract without penalties and maybe even get a refund for the fees I paid for services I never received.
Well, you may be entitled to that and more. We'll talk more about that later. But what I want to be sure of right now is what misrepresentation or misrepresentations they made to you. A misrepresentation is just a lie in common parlance. Can you identify anything that the manager or Lisa said specifically that was untruthful?
Yes, Lisa specifically said I would have access to exclusive classes and personal training sessions, but those were never available to me. It felt like a bait and switch.
So what was interesting about that process to me is that I had the students obviously read into the oral chat bot their particular factual scenario. With this individual, I just asked him to make something up out of the blue. And isn't it funny that he made up names, he made up a situation, he answered questions without any direction or guidance. If I had the time, I could have probed deeply into even who his family members were, how much he made a year, why this was burdensome, et cetera, and the chatbot will figure that out and give you good answers, at least for a student to use. But the students had to probe. That's what was incredible about it. It wasn't just a dialogue by a fellow lawyer or pre-lawyer who's sitting across from you in a chair. They don't know what's going to come out of the chatbot's mouth next, and they have to figure out how to develop the facts and figure out whether there's a claim or not, among many other things, as you all know. So chatbots have improved dramatically, as you can see up there. I think we're just about to the point that we can use them in these types of simulations. The delays and the gaps in responses as the LLMs get better are not nearly as bad. As you could see, it was practically almost duplexed back and forth. You know, there's less of a delay, I think. I took out some of the delays, but less of a delay than when you're on a conference call or Zoom, I think. And just the ability to generate these rich fact patterns is pretty amazing. Okay, this was a fun one. The Rule 59 motion for reconsideration. I asked the class, you know, what they knew about Rule 59. I don't remember that they knew much. You don't have that much time to spend on things like that in civil procedure. There's so much to cover, and yet you might just be expected to do a motion to reconsider or a Rule 59 motion when you're in practice. So it also, though, developed another skill. You're sitting there and you're thinking to yourself, I don't want to make the judge mad. I'll talk about that in a moment. But what I did, and you'll see a picture of it, I asked the model to create basically a fake opinion. Make up the judge, make it look like a West opinion, have head notes, have the judge's name, and make it look legit. But when you write it, embed erroneous statements of the law that we were going over that week to see them go through and say, well, wait, that's not right. That's not, you know, the scienter element that we're supposed to be dealing with. And then they had to push back and draft a Rule 59 motion to gently tell the judge that he really, really messed up. That's what the case looked like. Poor Judge Fellows. I'm still praying to this day there's not a fellow district judge out there with the last name Fellows, but because he really goofed, let me tell you. But it looks like a real case, and I think this one was spit out by Grok, if I remember correctly. I think Grok did this. ChatGPT was resistant for some reason to create a fake judicial opinion, even though they do it all the time. Here's the learning value I felt like out of this exercise, in addition to the particular drafting elements that were required. And you know, Rule 59 has an unusual standard as well. You don't just tell a judge he's wrong or she's wrong and you win. Obviously, there's much more to it than that under finality and other concerns. Next one was an expert witness simulation. This was a lot of fun, at least from my perspective. You know, how many young lawyers are going to go and interview an expert witness? Maybe not many, but they may help someone prepare for one. They may sit in on it in either a defense firm or a plaintiff's firm. And so I thought, you know what? This might be a perfect opportunity for them to engage in an interview with an expert witness and to talk about all sorts of things. So what I did was created 12 different products that were defective, okay? And they were defective in a certain way, caused an injury, and then the students were responsible for each particular scenario to question the expert and to see whether the expert was going to stand up. And they got into a lot of different areas, even fee negotiation, okay? And what I do when I ask them to do this so I can give them evaluative tips is I ask them to print out their chat transcript, okay? And, you know, the model saves everything. So I could see what they asked and what the responses were from the expert witness. And again, they really did a fantastic job, especially with fee negotiation. You know, where the expert was pushing to keep that fee, they gave good reasons why maybe a little bit of play in the joints should happen. But Daubert was a big one too. To ask questions about, have you ever faced a Daubert challenge before? Has one ever been successful? Do you see any flaws in your methodology or obvious areas where it's going to be challenged? Things like that, where they're putting the Daubert standard to the test. Incidentally, I know it's Daubert. You all may think I'm, you know, from out in the hills somewhere and I don't know what I'm talking about. But Judge Goodwin knew the judge who had that very case, and he actually got to meet Mr. Daubert. So this was just some of the things that I felt like helped develop some core lawyer skills and how the exercise worked. But there was one group. There was one group that the chatbot just would not come to heel. It kept weaving and meandering and changing the subject and going off, you know, on a tangent. And I thought, gosh, I wish that would have worked better. And then I thought to myself, no, that's wonderful. That's a learning experience in and of itself. You should have seen what a marvelous job the students did in trying to get that expert back on the rails and get refocused on what they were on the call about. Next one was a case valuation. We introduced them to how to look at a case and a set of facts and think, okay, how do I come up with that figure in a demand letter, for instance, or when I go into mediation? I didn't think that was something that students maybe were really exposed to before they got out of law school. But again, we tied it to the doctrine, okay? It's a products liability case. There's the fact pattern, just briefly. And the thing that was great is that the plaintiff's side had some things that only they knew about at the pre-filing stage, and the defense side had some things that only they knew about at the pre-filing stage. So that old basic formula for case valuation, as we know, it's a very imperfect formula. The students learned that. We had a lot of variables in there that could inch it one way or inch it another way on valuation, and maybe even go yards away, depending on how big of a deal the particular variable was. But the thing that was great, this is one of the times that the students used GenAI, was that they got their EV the old-fashioned way, but then they compared it with the LLM. They put in all of the information to the LLM, the chatbot, and it came up with its valuation. And then to look at that and do a comparison. And I think in most cases, they were pretty close. In some cases, they're wildly off, but what was great is that the chatbot gave justifications for its assumptions, and that was a learning opportunity as well. So another important lesson learned is that you're just not going to get one single number, and you're going to have to be willing to move. And you want to know that before, for instance, you give your opening offer or your response. So I tried to make things fun, and on each product liability example we had, I actually wore the item. The one that was my favorite is it had me standing on the edge of a canyon, and it was a personal flight device. So I'm getting ready to go off the canyon. Things didn't turn out well, as you might expect. But and all of this was made up by a chatbot, okay, with guidance from me and a prompt. And all of them got defendant and plaintiff scenarios in the imbalanced way that I talked about earlier. And, it did beautiful incident summaries for each and every one. You have to understand, these weren't generated over hours, okay? Generated all of these fact patterns, multitude of fact patterns, in again, probably 15 to 20 minutes, and then I tinkered with it for about 10 minutes more. I don't see any problem with that. The device emitted erratic high-intensity pulses. Maybe that's necessary. We have no idea. All right. So next we did mediation statements. And as you know, most cases mediate, whether it's in federal or state court, and had a very rich fact pattern, again, developed by ChatGPT, I believe, did this one. And you can see the product liability defect theories that were in play. And again, it was a long fact pattern. The students had to tease out all of this stuff from the fact patterns, and it might help them and their plaintiff, or it might hurt them. But they had to be in a position to defend it. So they had to do a 6 to 8 page mediation statement. And it wasn't about, it was still about the adversarial system, but it was about ADR too. A lot of students don't get an experience in that at all. And to actually jump into drafting a mediation statement and how you go about doing that and why it's so much different, for instance, than drafting a typical pleading or a summary judgment motion or something else. And non-monetary solutions as well, to think about those. And I've seen that influence clients whether to settle or not. I saw a plaintiff one time. It wasn't a case that I handled as a judge, but the plaintiff not only wanted the money, but wanted an apology from the officer who was alleged to have used excessive force. And the officer declined. The case went to trial. So that's something to be prepared for, and one reason something like that was thrown in. But again, the doctrinal was front and center for product liability, but there were also some drafting and some professional skills that were involved as well. And again, help them to see that they need not only to be prepared for the adversarial system in the traditional sense, but also in the ADR sense, because it was coming. Now this was the biggie, and this is where we'll end. I'm sure you are getting hungry. But I wanted to introduce you to the Verdi platform. It's really a pretty amazing thing, and I think honestly, it has the potential to change training generally, but particularly skills development in the legal academy. So this was how the AI mediator was set up. And do you remember those mediation statements that I had the students do the week before? Well, I took those and I preloaded them, I'll show you in a moment, into this mediator for each group. So follow me here for a second. We have 12 groups, okay? And then we have 6 cohorts. Each cohort is made up of 1 plaintiff group, 1 defendant group. So we have 6 cohorts that go before the mediator all at the same time during class time and mediate a case based on the mediation statement that they had submitted to me the week before, that I then loaded into the Verdi platform for this live mediation. So go ahead and take a look at that, and I want to give you a sample of the Verdi platform and a sample of what the students saw during the exercise. Let me demonstrate the Verdi platform. This was one of the cohorts for the mediation session in the Ramirez case. And you can see that's our mediator. I think I named him Robert Dexter. But what I wanted to show you is all of the toggles and the ability you have to control things. As you can imagine, it's a pretty complicated thing with an interactive avatar to have two different teams that are mediating a case on opposite sides. You have to let them exit at one point, perhaps the defendants, so he can speak with the plaintiffs alone, and then bring the defendants in and exit the plaintiffs, and then bring everyone together for a joint session. And so what I did was set up the mediation session, set a time limit, which unfortunately I didn't set it long enough, and a lot of students didn't get to finish. But several did bring in a settlement. But what you do here is, in essence, give it the role play that you want it to do. I tell it it's an advanced torts mediation simulation. And I have to tell you that I had a lot of help building this prompt from ChatGPT or one of the other chatbots, maybe it was Gemini, and explained to it. And I can set time limits, and it will follow the time limits and bring the quote lawyers unquote in for a landing at the appropriate time, and then shut things off when appropriate. And so that is only one section. You can then set ways for it to evaluate each mediation side. And I picked these right out of thin air. What was remarkable to me, though, is that the Gen AI bot working in the background knew precisely what I was talking about and was able to listen to the students and evaluate them. There may be something else here. You can add evaluations here. There's tools to tell you about evaluating. And then I set the name as Robert Dexter. I had an opening line that he was to use and that he was to start the conversation. And then again, I gave the scenario that I wanted him to use, and that he needed to be active but persistent, gave him a character. And then I gave him a sample conversation to sort of get a sense of how things would roll. As for the knowledge bank, this is where I put the students for each respective group, their mediation statements in. I uploaded the PDFs of their mediation statements that were submitted on this same case the previous class, and provided some additional instructions too. And you can see the rules that I imposed on him. Avoid judgmental language, and a variety of other things in there as well. Let me show you a preview. So this is what was displayed to the students before they started. Just a message, and told them how they were going to be evaluated.
Good afternoon. I am looking forward to this mediation session, and I welcome all of you to what I hope will be a successful session.
What do you think our chances of success are? I know that you've read the plaintiff's mediation statement. Do you think we're going to win a lot of money? I built in a pause for laughter.
Thank you for your question. Let me clarify my role here. I am not a judge, and I'm not here to predict outcomes or decide who's right or wrong. My job is to guide both sides in finding a resolution that you can reasonably live with, taking into account the risks, costs, and uncertainties of trial. That said, I've read your mediation statement closely, and I see you've raised significant points about the damages, the warning adequacy, and internal documents from the other side. The strength of your case will depend on how a jury may weigh those issues, along with any comparative fault arguments the defense has. Mediation is your opportunity to explore a productive resolution without leaving those decisions entirely to the unpredictability of a jury or court. Keep that in mind as we proceed. Let's focus on building options that align with your priorities.
I wish I could show you the entirety of what took place. It was pretty remarkable, to be honest with you. And bear in mind that he was speaking to the students in separate rooms throughout the law school as the two teams competed against one another in each room. It wasn't a perfect session, but I think if you talk to the students, although there were some hiccups, just because of the limitations with live avatars, that frankly, as I've noted, are getting better every day, it was a pretty amazing thing, really. So, in this, at the end, as the creator of the exercise, you will have the ability, of course, to get scores for the students on how they did. So one thing I wanted to mention to you is I wish, yeah, that's so nice. I'm glad that came up. Oh, for goodness sakes. I'll do anything to get sympathy. So the evaluation process is what blew my mind, okay? I had the students identify themselves. Like I would say, Your Honor, John Smith for the plaintiff. The chatbot picked up on the fact that that was student John Smith speaking, and it listened and it evaluated John Smith. And all the students took turns talking at different times. And the mediator even excused one side or the other if he wanted to have a specific session with them for a few minutes. And then he would say, for instance, to the plaintiffs, okay, please go out in the hallway and have the defendants come in. I need to talk to them for a while. It's really astonishing. This exercise took about, because I was new to the platform, I had never used it, about 2 hours to put together. It would take half that much time if I were to do it again. And that's sort of how the mediation went, if you're curious. And you can see that there's some similarities with a real mediation. Those are just some things that I thought sort of provided a unique opportunity for the students to have an experiential and valuable confrontation with what it's like to go in to an ADR session. Again, he wasn't perfect, but I'll guarantee you by the fall, I mean, he's not even on Verdi anymore to choose from. They've got a whole new class of AI avatars out there who are spot on and so much better. For that one exercise, I used this technology stack, okay? 2 years ago, I can remember that all I ever used was ChatGPT 3, and I was perfectly happy to stay there. What I would encourage you to do, what I did though is eventually got interested, intellectually curious to look at other platforms, and I would tell you to do the same, okay? Be careful when you do it. You don't want it training on your data. You know, there's plenty of YouTube videos out there, good ones from reputable sources, who will tell you how to protect your privacy and to use these platforms effectively. But with this type of thing, you know, it may be overwhelming to sit there and look and think, well, gosh, I don't know anything. 4 platforms, are you kidding me? I remember when I was little, I told my mom and dad I wanted a toolbox for Christmas. And they gave me the toolbox, and then it dawned on me, gosh, I should have asked for tools. But I opened it up, and they realized that I needed at least one tool. So there was a little hammer in there. And I, for the next 7 months, was all about getting another tool, getting another tool, getting another tool. And that's the approach that you should take to developing this skill set. The question that Zach had earlier for one of the panelists was just fantastic. How do I go about slowly building my expertise in this area? So I had some other things that I wanted to share with you, but I'm also sensitive to the fact that it is a Friday afternoon and I'm probably going to go over, and I really want to make time for questions to the extent you have any. So before I go into anything else, let's go ahead and open it up for questions. Thank you very much.
Hello, Your Honor. I'm so glad you used the witness avatars because this is a topic that's been on my mind since last summer-ish. I saw a news article out of Arizona where a witness or a victim impact statement was delivered by an avatar of a deceased man who was killed in a road rage incident. And it blew my mind. A, that it was permitted, but then it just got me thinking, you know, what are the possibilities? What is the likelihood that this is actually going to become something that is used with any frequency? I was thinking about personal injury cases, medical malpractice, anything where we have a decedent who we want to be able to portray, you know, in as live of a format as we can. So just really interested in your thoughts on use of that technology for actual witness statements in court.
So I think I'd definitely be interested in the sentencing phase. I guess my biggest concern would be overpowering the will of the jury. That could be extraordinarily powerful. You know, you're not dealing with the real person. For instance, I have done an avatar of myself. It sounds like me, it looks like me, it talks like me in an unscripted manner, and I can make it more sympathetic. I can make it slow down and speak into the camera. You can choreograph them to the extent that it doesn't in the end even look like the decedent. And that's something where I think you have to be careful. I'm still cautious in a lot of ways when it comes to what's presented in court, how Gen AI is used in the litigation process. Actually, this is interesting. You'll be the first public group I've shared this with, I believe. But I created with a friend of mine who's in our IT department, we actually went through line by line and coded it, a hallucination detector. And what happens is the program goes out and gets all of the briefs, memos, objections to PFRs, everything there could be legal authority in from the CMECF filing system the day prior, pulls all of them, pulls all those Adobe documents, puts them into one Adobe document, so I have everything that was filed that day before, then I drop it into Lexis, and it looks for fake cases, and it looks for hallucinated quotes. And it has worked. I've entered at least one order to show cause, and I think that courts are going to start using that when we do finally roll it out. But, you know, it can really corrupt the legal process if it's used inappropriately. That's why I want us to be teaching it in the academy, the right way to use it, the limitations, the benefits, the appropriate uses, and those that you have to steer clear of. I tell every ear that ever listens to me, do not use a chatbot for legal research. They were not made to do that, and a whole bunch of other things that Professor Seifert could probably tell you about. Excellent question. Other questions?
So as a law professor, I was extremely impressed with this. I think it's fabulous. As a researcher in, from time to time, the intelligence tutoring community, one question that came to mind is, suppose you had to objectively evaluate or measure learning from these activities. You showed us pedagogical value for each one of those. It sounds plausible, but I just was curious if you had any intuitions about objectively demonstrating learning.
So it's funny. I actually got IRB approval, went through and did a questionnaire. It's very difficult to pull things out objectively because I wanted to focus on my particular class, obviously a very small sample size. So I don't even know that my results, the article about this is in the publication process right now. I'm not even sure I'm going to use the survey results. I think one thing that I can say confidently, though, is that students, based on their responses, learned that you can't trust AI, okay? And you may think, well, everybody knows that. That's not true, okay? Here's what happens to even seasoned users. They will put 5 prompts in over a period of a week or two, get really good, solid results, and then they stop checking. And that's when they get bitten. They assume that it's going to predict right, okay? 100% of the time. And that's dangerous. But I'm going to have to leave it to bigger minds in academia to figure out how you measure the learning value. Good question. Other questions? Any questions about the platform or the use or anything that I was vague on? I really had to rush, unfortunately.
Thank you, Judge. I wanted to ask you, every way that you implemented this, and I went through all of that in your Torts 2 class, the way that you use it, and I saw you also do a talk for UCLA, I think it was, or one of the University of California schools, where you used a chatbot video simulator to practice for yourself arguing and responding to live objections, right? So every way that you've implemented these tools is essentially a way to hone skills and to, for lack of a better word, play with them, but not necessarily do the practice of law, of drafting, of doing the things. At what point do you demarcate in the line, you make a line between honing a skill and then turning off all of the AI platforms and then going on to Word? And where's that line for you in terms of what's appropriate?
Well, what I would say is, very good question, Caden. We all know how trial lawyers get better, hopefully. It's experience. It's dealing with the unpredictable. It's pivoting from that difficult question or that really hard objection that you have to respond to, or that objection you have to make and that maybe you missed and you learned from it. The thing that's great about the interactive chatbots, I'm not trying a lot of cases right now. Past 6 months, I haven't had a single one. Well, that muscle about the rules of evidence starts to go weak and atrophy if you don't use it. Those avatars are a magnificent way to keep sharp. They will develop the scenario for you and say, okay, I'm going to start asking questions of the witness. And then I have to figure out, when an objection is made, how I'm going to rule on that objection. But it can, again, simulate it. But the real life is different. The real life breathing person is different. But this is a lot better than what we had prior to it, okay? I used to have a sheet of evidence rules and objections that I would go through before each trial to stay sharp. Now I can really practice it in an interactive way and maybe run less of a risk of looking like a fool on the bench, which I'm always all for. So go ahead, Professor. Incrementally, she asked how I trained myself on this. What I would recommend you do is start finding information feeds, okay? Daily emails. The Rundown is one. There's millions of others out there. You want to get good ones who will give you excellent use cases. In other words, something you might use a chatbot for that you had never thought about using it before. And also tell you about the apps that are out there. I can't tell you how many times I've been looking through a daily email, and sometimes it takes me a couple hours to go through them, like I said, and I think, oh, wow, that looks cool. And I'll go out and play with it for 10 minutes, and boom, all of a sudden you've got a new tool in your toolbox. My wife, I wanted to get my wife a really unique birthday present. She doesn't need anything, so I went out and I found an AI song generator. This is months ago when they were new. It did a fantastic country music song. I was able to give it the idea for the lyrics and tweak it and everything else. And it starts playing, and she's sitting there thinking, why is he playing this song for me on my birthday? And then it clicks about 4 or 5 verses in. It's about her and us. It was really, really amazing. So it's not just, work-related and everything else. There's a whole lot of other stuff out there that's very, very interesting. This program that you see up here, I hope that some of you enjoyed the PowerPoint presentation. It's called Gamma, though. It's online. Gamma, G-A-M-M-A. For class, some of my students in here have seen them, but I don't think I've told them about the platform. I think I just wanted them to think I was really smart and did great presentations. But I've put my lecture notes in and walk away for 15 minutes and get a cup of coffee and come back to this. And it's pretty doggone incredible. And it's frankly pretty cheap as well. Excellent presentations. And to make sure I don't miss anything, hopefully it's in fair use, I'll even put in the reading assignment. okay, to make sure that I can go through the slides and say, oh gosh, I missed that note case. I want to make sure I mention that principle. But it's extremely helpful. Now, you're worried about hallucinations? You should be, but go through it. And if you are isolating on just your lecture notes, it lets you push a button that says preserve text, and it will spit out exactly what you put in your lecture notes. And then you can tweak it. You know, maybe that's too much. You can pull out a slide or pull out some language. It's fully editable. You can even download it, export it to PowerPoint. It looks and runs exactly like that. It even preserved my links in this presentation when I exported it for safety. Always have a backup. When I exported it for safety, it even preserved my links to the YouTube videos that you saw. Really great stuff. Other questions? I don't have anywhere else to be. I'm happy to answer anything you'd like. And if anybody has to leave, please feel free to go.
Are you using that same combination of generative platforms for your objections, your objection practice? Was that those four, or?
I've tried a few different ones, and it's so funny. I just had a professor up here say, my students are asking, how can we practice our objections? How can we practice, you know, what we do in Luger and things like that? And I mentioned this, but HeyGen is a good place to practice it. It's HeyGen. They have free trials. I think they may also have student, I can't keep track of which ones have student or new user discounts, but that's a good one and very easy. That's the one I demonstrated up there just moments ago. But you can find live avatars elsewhere as well, so there's multiple platforms. But I'd have to say I've tried 2 or 3 others. I haven't liked them as well as HeyGen.
Okay, thank you.
You're welcome.
Anything else?
Is there going to be a Kahoot for a $5 Starbucks gift card?
I always do Kahoot quizzes, but I'm not doing one today. When I do quizzes in class, I do it through a platform. And then whoever wins gets a tiny little gold trophy and a $5 Starbucks gift card. I've changed it to 10 now. These things are so expensive. And I think that buys you half a cup of coffee. I can't remember how much, but anyway. Other questions?
All right, well, let's give a big round of applause to
Thank you very
Chief Judge
much.
Volk.